Hello, and welcome to all the participants who have registered to join us today for this expert roundtable on the ICC policies on the crime against humanity of gender persecution, gender-based crimes, and crimes against and affecting children. This event is the fifth in our series related to the Office of the Prosecutor's policy on gender persecution. In this conversation, we will focus on gender persecution as it relates to the updated policies on gender-based crimes and crimes against and affecting children, which were presented to the Assembly of States parties to the International Criminal Court earlier this month in New York. My name is Milena Stereo, and I'm the Charles R. Emmerich Jr. Calfee, Halter, and Griswold Professor of Law at Cleveland State University's College of Law, and also Managing Director at the Public International Law and Policy Group, and I'm honored to be guiding the conversation with my colleagues. Over the past few years, the Office of the Prosecutor has been actively working on updating and developing thematic policies to improve the understanding and application of the crimes falling under the jurisdiction of the International Criminal Court. During the 21st session of the Assembly of States Parties in December 2022, the ICC prosecutor presented and officially launched the policy on the crime of gender persecution. During the 22nd session of the Assembly of States Parties, which just took place from the 4th to the 14th of December of this year in New York, the Office of the Prosecutor presented the updated policy papers on gender-based crimes and crimes against and affecting children. In this context, this event will discuss how these policy papers interact and specifically their connection with the crime of persecution. We're honored to be joined today by Professor Lisa Davis, Professor Kim Thuy-Seelinger, and Véronique Aubert. The roundtable will be 60 minutes long, and we ask that you please submit any questions that you have for our speakers using the Q&A function, and we will do our best to answer your questions either throughout the event or towards the end of the event. Now, allow me just a few minutes to introduce our panelists. Our returning champion here is Professor Lisa Davis, Special Advisor on Gender Persecution to the International Criminal Court's prosecutor, and also an Associate Professor of Law and Co-Director of the Human Rights and Gender Justice Clinic at CUNY Law School. Professor Davis has written and reported extensively on international human rights and gender issues, including women's rights and LGBTQI+ rights, with a focus on peace building and security issues in conflict and disaster settings. I'm also thrilled to introduce Professor Kim Thuy-Seelinger, an expert on gender-based crimes in the context of armed conflict and forced displacement. She's a research associate professor of social work, public health, and social policy, and a visiting professor of law at Washington University in St. Louis, where she also directs the Center for Human Rights, Gender, and Migration. And she's on academic leave at the moment, working at the International Criminal Court, where she has since 2021 served the prosecutor as his special advisor for sexual violence in conflict. And welcome to Véronique Aubert, a senior human rights expert with over 20 years of experience in fact-finding missions, investigating gross violations against children in conflict settings, and promoting governments and armed actors' compliance with international law standards. She's the special advisor on crimes against and affecting children to the International Criminal Court prosecutor, and she will be speaking here today in her independent capacity. Welcome, everyone, and thank you so much for agreeing to participate in today's panel. We're going to start with Kim. So Kim, can you tell us a little bit about the updated policy paper on gender-based crimes? And in particular, have there been changes made in the current policy vis-a-vis the prior policy that has been around for some years now?
Yeah, thanks, Milena. I'm laughing a little bit at how you introduced us, because by having Lisa introduced as the returning champ makes it seem very adversarial, like I'm supposed to wrestle her down or something. But trust me, we're all partners in this work and there's no contest. But anyway, yes, to your question, as everyone I think probably is aware, we had our original policy on these issues issued in 2014, and that was the policy on sexual and gender-based crimes. So for a number of reasons, the prosecutor really wanted to take the opportunity almost a decade later to review that policy and make sure it was still fit for purpose and reflected sort of lessons learned in these last several years, and make sure we reflect current understanding of best practices, which also led to even a renaming of the policy. So one change or development that I would highlight at the outset is the policy we just launched, the revised policy we just launched at ASP last week, is now titled it's the OTP policy on gender-based crimes as opposed to sexual and gender-based crimes. And we did this for a reason. We're trying to clarify the conceptualization of this type of violence and crimes that entail this type of violence, and realize that sometimes the sexual, was feeding into what can often be a myopic focus on sexual crimes, when there are many kinds of gender-based crimes, some of which are sexual in nature, some of which are reproductive in nature, some of which are gendered in other ways and other reasons, and some, a combination. So you'll see in the policy, there's a Venn diagram that tries to tease some of this out. And so that was one of the conceptual refinements. It's a policy on gender-based crimes with the understanding and explanation this covers sexual violence in crimes under the Rome Statute, but also crimes that involve reproductive violence and other forms of gender-based violence. And in focusing on these forms of violence at the outset, we were trying to highlight the fact that these forms of violence may manifest all over the Rome Statute. We're not limited to looking at, Article 7.1g, for example, which is the, part of one of the famous lists of the crimes that we tend to look at when we think about gender-based crimes. We're asking the Office of the Prosecutor, our team, to widen the aperture of how we see crimes under the Rome Statute and understand that many of them throughout the statute, not just Article 7.1g, for example, do involve or can involve sexual violence, reproductive violence, and other forms of gender-based violence. And in that way, they are, to some degree, either explicitly or more indirectly, gender-based crimes. And so a second and related point, which we develop in the new policy, is that in order to get to that understanding, to see the different forms of violence and then understand what crimes might be implicated under the Rome Statute, we have to take an intersectional and gender competent analysis to how we look at the facts before us, so that we really understand in all cases, is something gendered in motive or in form or in its meaning or its impacts, right? If we understand that and we undertake an intersectional analysis, then that allows us to charge as appropriate, whether it be one of the enumerated crimes under Article 7.1g or as a crime under something else in the statute. There are obviously gender-based crimes that might fall under, the many types of genocide that we see, and there are also gender-based crimes that might manifest as war crimes. So it just it widens the frame a little bit for us, and that's something we wanted to accentuate in this new policy. You'll see in the policy also that we tried to get at some of the challenges. We tried to be as frank and introspective as possible in the drafting of this policy, and that entailed a lot of sort of internal thinking and feedback, but also critique and inviting comment from external colleagues from civil society and national jurisdictions and other mechanisms, and try to identify some of the myths and misconceptions and barriers institutionally and even at personal levels that have been impeding our ability to investigate and prosecute these crimes fully. So you'll see there's a whole section in the principles part of the policy that deals with addressing our own biases, actually, and really targets some of the impediments to looking very clearly and fully at these crimes. The latter part of the policy deals with practical issues, like how do we take the policies that are outlined earlier in the principles, that are outlined earlier in the policy and operationalize them through every phase of our work. So you'll see that in the phases section of the policy, we walk through every stage from preliminary examination through the trial, through appeals, even we have a section on reparations, just trying to show what this means actually to implement the principles at every step of our work. And I guess one other development that I'll touch on from the policy is while this was a really introspective exercise, we also were very conscious of the need to be as inclusive and relevant externally as possible. Our primary audience, of course, has to be the OTP. Like this policy is supposed to guide us in how we do our work and strengthen our approach to these crimes as an office here at the ICC. But there's such great value, of course, in looking at what's happening in national systems around the world. And that we were super grateful to have input from colleagues all over the world, from Colombia, colleagues who are working in Africa, colleagues who are working in courts in Europe through the principle of universal jurisdiction, for example. And so we wrote the policy with complementarity in mind and also accessibility and dissemination in mind. So we're looking forward to additional translations. Right now, it's obviously we rolled it out only in English and French in time for ASP, but we're looking at other languages early in the year. We also wrote it at the line level so that as little as possible could get lost in translation. We wrote it as leanly and clearly as possible. And you'll see reference to jurisprudence and developments and lessons learned from other jurisdictions. So in that way, we really wanted to reflect the OTP's place in a broader ecosystem of justice for these crimes. So maybe I'll stop there, but I'm looking forward to my colleagues' comments on the other policies. Thanks.
Thank you so much, Kim, for that answer. And before I go on, I just wanted to clarify when I say that Lisa is our returning champion, what I mean by that is that we have already held 4 prior roundtables of a similar format, highlighting various aspects of the policy on gender persecution, prosecuting the crime of gender persecution. And so I believe that Lisa is with us here today for the 5th time. Otherwise, this format is definitely not meant to be adversarial. I know all of you are colleagues and friends, and we want to have a nice discussion and conversation. So my next question is for Veronique, and it's a similar question. If you can just highlight for us what the new policy or the updated policy on children, how does it differ from the prior policy, and what are some perhaps new or more innovative things in the new updated version of the policy?
Yeah, thank you, Milena. I just have to say that I'm really pleased that we are discussing today about gender persecution committed against children, because this is very much a very important issue, but very much overlooked topic in national and international proceedings. Just to put things into context, as special advisor on crimes against and affecting children, I first would like to refer to Article 54 of the Rome Statute, which mandates the Office of the Prosecutor to give particular consideration to sexual violence, gender violence, and violence against children in its investigation and prosecution. So, like he mentioned, for the children policy, it was in 2016 that the office issued its first policy, which was a really incredible milestone at the time to really try to advance the visibility of crimes affecting children. Considering development in jurisprudence in the last years, research, best practices that have very much evolved since 2016, including through technology and other, the office issued its revised policy last week. And I also would like to thank, I know many online, as well as Kim, Lisa on the panel have made fantastic contribution by sharing their wisdom and expertise. The key objective of the policy is to make sure that children do not remain invisible in court proceedings and that their voice be heard in each country situation. Sounds like a given, but as we know, conflict affects children in a variety of ways, depending on personal characteristics, including gender, age, disability, ethnicity, religious, where they live, their level of education, and so forth. So in the policy, we really try to reflect how that, like adults, children actually do experience serious physical harm as a result of the crime. They might die or be gravely injured from beatings or deprivation of food, water, medical care, from being recruited or used by armed actors, and so forth. However, that international criminal justice mechanism, including the International Criminal Court, have actually not listened enough to children's voices and their experience. So we've tried to explain that this exclusion is in part due to a general invisibility of children in the international criminal justice field. For example, children's experiences of atrocity crimes are often addressed only as part of the broader crimes committed against a civilian population, with limited age disaggregated analysis of how children of all gender are actually specifically impacted by the violence, and how children of different ages may themselves have diverse experience. So that's why we really recommend that a child identity be taken as multi-dimensional and reflecting not only the specific age, but also other aspects such as their gender, and as I mentioned, religion, ethnicity, socioeconomic status, and so forth. But I will really recommend that everyone read the policy. And just to conclude this question, I will just highlight a few key objectives. The first one is the fact that the policy, we really tried to aim to help remedy this historical underrepresentation and lack of engagement of children in international criminal justice processes, to emphasize its views that all crimes under the Rome Statute may be committed against children or otherwise affect children in a myriad of ways, and we try to articulate how and where. Third, to ensure that in dealing related to children, the Office of the Prosecutor takes a child rights, child sensitive, and child competent approach guided by the best interest of the child. And but believe it or not, those concepts are very complex, but thanks to the collaboration and cooperation of so many experts, I think we enable to sort of clarify and articulate clearly what that implies. Then to actively reflect and adapt to issues related to intersectionality, children, different developmental stages and their evolving capacities and abilities. Then to emphasize the prosecutor commitment to establish an institutional environment that actually facilitates effective investigation and prosecution of crimes against and affecting children, including through the recruitment, training, external collaboration, and meaningful implementation, monitoring, and evaluation measures. And finally, to promote the exchange of lessons learned and best practices stemming from local domestic expertise with international accountability effort. A lot is already happening at the domestic level, and we have a lot to learn at the international level from this expertise. So the key thing to remember, which is new in this policy, is really the fact that the prosecutor's vision that children's voice be heard and reflected in all the office's cases. This means that the office will proactively and explicitly consider children's experience in every situation analysis, while also ensuring its capacity, obviously, to safely engage child witnesses where appropriate and in the best interest. Thank you.
Thank you so much for this very excellent and comprehensive answer. Let me now go to Lisa. So Lisa, when you read and I know you were consulted in the drafting of these additional updated policies, but where do you see the connections between these two updated policies and the policy on gender persecution, which the Office of the Prosecutor released a year ago, where I know you were the primary drafter? What are some of the connections between now the three policies?
Well, I think these three policies, they really work together to form a holistic approach to addressing justice for victims. I mean, just to take a step back, I'm often asked the question of what's the difference between the gender-based crimes policy paper and the gender persecution policy paper? So the difference is this: gender persecution is the charge that we can bring. It's one of the holistic charges that we have. likely the only holistic charge we have that can really highlight when a crime has been committed with that intent to discriminate based on gender. So it's a really important crime. And the problem, of course, is that even though it's been on the law books for decades, it's been in the Rome Statute for 20, 25 years, we've never, ever had a single successful prosecution of gender persecution at the court, ever. So what does that tell you? I mean, hopefully that's going to change very, very soon, knock on wood, with the Hassan case, which is going to be coming out soon. But there's a reason why there's been a dearth of these cases. And the reason is because, well, one, we have this outdated definition of gender that's in the Rome Statute that's never been used again in any other treaty or mechanism. And we don't have an understanding of gender crimes. And that has changed. The international community has involved, customary international law has involved, and it became apparent that we needed a policy to explain how to charge these crimes. At the same time, the policy paper on sexual and gender-based crimes from 2014 was also outdated. So, closer in time, but it also shows you how 5 or 10 years can really make a difference in the discourse on a crime and customary international law and our understanding of it. And I would say the same is true for the policy on children, that our understanding of the deeply complex and nuanced nature of how kids are affected by all crimes, and we need to be able to recognize that instead of stereotyping them or siloing them into specific crimes that might happen, but sometimes outshadow or, as Veronique pointed out, invisibilize all the other crimes that do also happen to children, that we needed a way to be able to address that. So the gender-based crimes policy paper, as Kim so eloquently put it, it widens the aperture for the court to understand crimes, because any crime under the statute has the potential to be a gender-based crime, that it widens our understanding of those crimes as gender-based crimes. And then the gender persecution policy paper gives us a tool for when those crimes that we understand as gender-based crimes, when they meet the standard to be charged as gender persecution. And then what Vero has done with the policy paper that she worked on and Kim worked on was the children's policy paper then brings us a holistic picture of how this affects kids. So we spend a lot of time in the policy paper on persecution talking about adults and kids and LGBT people and men and women and all the different various forms or groups that might be targeted by perpetrators. But we don't have as robust of a focus on kids, and that's what the policy on children does. It gives us that robust focus. It gives us that way to be able to understand them. Layer the gender-based crimes policy paper on top of it, and you can see the gender nature of these crimes. And then take in the gender persecution policy, and you have a way to charge these crimes. So this is how the three of these papers really work together. They all drew on civil society input. They were workshopped. They were deliberated on through a very long process. And I think what we have is a great product at the end, and a tool not only for the court to be able to bring forward justice for victims, but really tools for any accountability mechanism that might be looking at these same crimes.
Thank you, Lisa. And actually, let me go to one of the questions that we just received from one of our audience members. You've partially answered this question, Lisa, but let me read it and let me see if anybody wants to add to this. So the question goes as follows: why is it important to have these policies? Wouldn't the ICC prosecute some of these crimes without the policies? Do they add any new elements? So Lisa, you've already, partially answered the question, but what do you think? If we didn't have these policies, wouldn't some of these crimes be investigated and prosecuted anyhow? Go ahead.
With regard to investigating crimes against and affecting children, when I mentioned historically there's been under investigation and under prosecution, I didn't say it lightly. I mean, since Nuremberg, in the international front, there's been very, very little expertise built. in analysis, in investigation, in prosecution. And this has snowballed to the point where crimes against children have remained completely invisible. So I very much hope that this policy will actually not only provide some concrete recommendations, and again, it's been really exciting to have 186 experts, including from 30 countries around the world, where this is happening on a daily basis, and to provide concrete suggestions and recommendation on how to proceed, but also to help build confidence. This is happening at the national level. This can happen at the international level. What we cannot is continue to ignore children. And so we can hope that the policy will help the ICC, other international judicial, non-judicial mechanisms, as well as in some situations domestically. So that actually provide guidance, suggestions, but of course it's open for feedback and more reflection, and it's a live process. Things will evolve, but at the moment, let's hope this can help equip and build confidence to actually stop ignoring and keeping invisibility on crimes against children, mostly.
Kim?
I want to, yeah, I'm grateful for the question because, one wishes that one didn't have to ask that, but I think the truth is, we've had trouble. We've been unable to really stick a landing on gender-based crimes for many years. It's only quite recent, in the last couple of years, that we have a secured conviction, right, for gender-based crimes, and I think it's been an area of some challenge at the court, and having a policy does a couple of things. So on one hand, the prosecutor really, when he took office, he was very explicit about wanting to make sure that we strengthen our approach to these crimes. As Vero mentioned, these are strategic priorities for the court. We're mandated in the Rome Statute to pay particular attention to these crimes. And so this was an incoming commitment from Prosecutor Khan. And so I think part of needing to reissue a policy on children, a policy on gender-based crimes, and articulate a policy for gender persecution was to remedy some of the lack of progress, I think, in these areas, as Vero mentioned. So it's a public statement of what we want to do. And by putting it out publicly, it holds us a little bit more accountable. It also, within the office, really it becomes incumbent on everyone in the OTP, whether you are in preliminary examination, whether you are an investigator, an analyst, you're a trial lawyer, you work in the appeals section. The policy helps articulate how this is everyone's business. It's not just whether the investigators manage to do an interview with a survivor of gender-based crimes. Like, this has to be part of our planning. It has to be part of how we do our due diligence. It has to be part of it how we think about a survivor-centered and trauma-informed approach to protection in the courtroom and in psychosocial support as needed. So the policy is important because there are many things that weren't happening consistently, right? And you have, as in any large team, you have variation in people's receptivity or sensitivity or competence on these issues. And so the policy is an articulation of where we need to be. And you'll see in the policy, and I was pretty explicit about this, there is a commitment and more directive about actual implementation and monitoring and evaluation, what we're committing to do. And since stepping into the court now as staff, that will fall largely to me. And this is where a little bit of my public health hat will come in useful. I think as lawyers, we're not trained to think about implementation or dissemination or monitoring evaluation, but it's something that we need to do so we can have a fuller understanding of what we're not doing or where we need to improve, I guess, as an office. So I think there is a need for a policy because the truth is sometimes these crimes are not being investigated or prosecuted rigorously enough for some of the biases that you'll see in the policies and for the traditional invisibility of children, as Veronique mentioned. So I guess that's what I would add there. I think the policy is a commitment and it's binding on the office.
Thank you. Lisa, anything to add on this point, or?
No, I think my my colleagues pretty much summed it up. I think as accountability mechanisms, whether it's the ICC or other accountability mechanisms, having statutes that you follow is not enough because we need to understand the context around what those statute means. There's very little out there that really explains how kids are affected by crimes, about how crimes can be gender-based crimes, whether they're reproductive crimes or sexual violence crimes or not reproductive or sexual violence crimes, but still amount to gender-based crimes. And I think sometimes we get this when we see a prosecution for a gender-based, for a sexual violence or reproductive crime, we say, aha, okay, we have gender-based crimes that have been accounted for. But we don't say that for crimes that are not sexual violence or reproductive violence crimes. We don't say, aha, we have a gender-based crime that's been accounted for, because we don't often think about gender-based crimes as being broader than sexual and reproductive violence crimes. And we need to think about them as being broader. And, and we need to think about them as happening to kids, because they do, both sexual violence and reproductive violence. So we need to be thinking about this in a more interrelated and dimensional sense. And that's what the policy papers help us do. They help us connect the dots.
And I actually have a question for you, Lisa, related to something that you said, but I don't want to steal your thunder. We'll return to it in just a few moments. But let me go back to Veronique and ask to follow up on essentially how the crime of persecution, how does it sort of flow? How is it present in all three of these policies? So for example, how is gender persecution perceived through the lens of the new updated policy on children?
Thanks, Milena. So the policy, and thanks, of course, from Kim's input, but also Lisa's input, really tried to highlight the fact that where children are explicitly considered to be victims of crimes, their experience have typically been treated in a reductionist way with gender stereotypes. And so we try to explain what we mean by that by giving the example of boys, and that has been the case at the ICC, where boys have been considered as primary victim of recruitment and use of soldier in hostilities. When, many occasions, girls only come into view in the context of sexual violence because girls are statistically more at risk and impacted by sexual violence, ignoring the sexual violence often inflicted on boys recruited, for example, but also rarely reflecting the many girls that are themselves recruited by the groups. So regarding the crimes against humanity of persecution, the policy really tried to and requires that the office of the prosecutor go deep and assess whether children were targeted based on one or on more grounds, including age, but also their gender, their sexual orientation, their identity, occupation, and so forth, as well as political, racial, national, ethnic, cultural, religious ground, and so forth. And so the policy clearly articulates that whenever there is sufficient evidence, the office will charge the crimes of persecution based on multiple intersecting grounds and or in combination with other crimes against and affecting children, in order to really properly characterize this fact and fully reflect the harm suffered by children in a specific case. So the policy really states that the office will bring charges for gender persecution whenever, of course, there is sufficient evidence. For example, in a case involving the war crime of using, conscripting, and enlisting children, as I was giving before, the office will consider whether it is appropriate, based on the specific fact and circumstances, to also charge the crime of gender persecution. The policy also notes in particular that gender persecution often drives crimes against children and can reflect the continuum of historical and long-standing structural discrimination and fundamental rights deprivation experienced by girls. But I think part of the novelty, which wasn't in the 2016 policy, is the focus of the policy on a child whose gender identity or sexual orientation does not conform to social norm, and highlighting that in this case, it may also, the child might also be subjected to violence and gender persecution. And the policy tried to explain that in the absence of a gender-sensitive analysis, violence impacting LGBTQI plus children in particular in conflict-related sexual violence, well, won't be documented or analyzed, for example, while the targeting of persons based on their actual or perceived gender identity in many places, we know is actually prevalent despite the raising awareness and strengthened effort in advocacy. And that's really this articulation, which is quite different from the 2016 policy. So the policy really highlights the importance of adopting in an intersectionality approach. And in the context of gender persecution, gender may effectively really intersect with other forms of discrimination. And I'm just going to conclude with an example of a child who might be a young female and a member of a particular ethnicity or religion that might be more targeted for enslavement or sexual violence due to the discriminatory assumption about her age, gender, and ethnic and religious identity. And so those connections with gender persecution and gender-based violence have been quite developed in this new version of the policy, which is different from the previous version.
Thank you. And your answer is a great segue to my next question to Lisa, which is as follows. So the policy on gender persecution also considers how gender persecution can be committed against children. So can you tell us a little bit more about this intersectionality and how can this lens of gender persecution better address the sometimes horrific experiences of children during war?
Sure. When I started writing the policy on gender persecution, I went to Vero and Kim, and when I was talking to Vero, I said, we need to be able to include an analysis of kids in this. So we immediately started talking about some of the more well-known cases of violence against children in conflict, child soldiers, things like that. But then we also started talking about the less well-known and less documented cases of violence against kids in conflict. For example, in Colombia, boys being forced to fight who didn't present as masculine enough, and then being forcibly displaced afterwards if they lost. Girls being used as suicide bombers, because not just because they blend in or they might make that crime easier to execute, but also because they were seen as dispensable, right? And so this was the role that was assigned to them. Looking at these cases, we started to realize that there are a lot of nuances around how kids experience violence and conflict. And then we started looking at LGBT kids. And we said, well, what about LGBT kids in conflict? What happens to them? So Vera went and checked with children's organizations. I went and checked with LGBT organizations. And when we came back together, we had almost nothing. So there's very little documentation of LGBT kids in conflict and what happens to them. And so this is a whole area that we really need to explore, that we need to be spending time, that NGOs should be looking at in terms of this issue. So we try to include these issues in all of the policy papers, but in the persecution policy paper, we also said, well, let's take a step back. What happens when kids are affected if we don't see it as gendered? So, for example, there's a bombing of a school, and an investigator may go in and look at that bombing and say, well, I see male teachers who died, the principal, the custodian, I see female teachers and girls, but I see a mix of people and victims in this bombing. I don't see gender persecution. But unless that investigator takes a step back and says, what was the intent behind that bombing? Was it because the perpetrator was trying to enforce a policy that girls couldn't go to school? Then it becomes gender persecution, and it becomes gender persecution about girls, right? That's what it becomes. And of course, under persecution, all of the victims in that bombing come in as part of the targeted group. But it's why they're targeted that matters. Why are the male teachers and the female teachers and the kids targeted? They're targeted because of discrimination against girls. And we need to be able to highlight that. We need to be able to recognize it, and we need to be able to charge it if we're going to be able to truly address crimes that are committed against children.
Thank you. My next question is for Kim. Kim, gender-based crimes are, of course, also deeply connected to both the crime of gender persecution and also crimes that are committed against children. So could you also follow up on this theme of how are all these crimes connected?
Yeah, I'm happy to, Melinda. I'm going to try not to be redundant because I think Vero and Lisa have given so much already that in part answers this question. So let me revisit my initial thinking for this question and try to just focus on what hasn't been really already well offered by my colleagues. So in terms of the policy, I mean, Lisa's always reminded us, right, that gender persecution is about discrimination. And so I think it really clicked for me, embarrassed to say, like more recently than I'd like to admit, that this is one way that it really adds to the fullness of our understanding and our charging, because the other crimes in the Rome Statute, normally if you look at our elements of crimes, there's a bit of conduct, maybe there's an intent to do that conduct, and maybe there's some circumstances surrounding that conduct, and those are the elements we tend to look at. Whereas, you know, if the key to gender persecution is looking behind the conduct and around the conduct to the traditions and the systems of discrimination that influence that conduct or the choice of that conduct, that is what I think, you know, Lisa's always been telling us, is that the holistic thing, it fills in the ether, right? It fills in what is around the specific acts we're looking at for most of our other crimes. So I think that's super important, whether we're talking about gender-based crimes or crimes against children. The gender norms that exist prior to the attack we're talking about or the conflict we're talking about are relevant. The norms around children and around age generally prior to are also important to understand the crimes against children and our ability to detect them and understand the meaning of them. So I think that's one, some maybe more conceptual relationship among these crimes. I do think that I mean, Vero and Lisa have given us so much already about the relationship between gender persecution and the children and crimes against children. One thing that maybe I'll add a couple of things here. In the gender-based crimes policy and the children's policy, there was a benefit to sort of drafting them in parallel. We were able to highlight not just crimes that were directly targeting children for some reason. Obviously, children can be affected and, you know, and implicated in many ways. Crimes happen to them alongside adults, right? People don't necessarily always discriminate based on age, and sometimes they do. So there's that. There's also when children are specifically targeted because of their age or their vulnerability or their status in society or their perceived utility or whatever it might be, as Vero's already mentioned. And then there's, you know, there are the way children are instrumentalized in the harm of others, right? And can be affected by the harm visited upon others. So, for example, if we think about like torture, which of course can be a gender-based crime itself, we have so many situations, right, where family members are forced to watch, forced to witness harm to their other family members. And this works in two ways, right? Parents were threatened with the harm, you know, the rape of their child or the sexual torture of their child, or vice versa, children who are forced to watch, say, their mother raped by armed actors. Like the policies interplay with each other because these situations and these crimes are really dynamic, and the actions and the impacts of actions affect people of different ages in different ways. And so we try to link those scenarios up in the policies a bit and be mindful of the fact that age is relevant to all of this. And listening to Vero and thinking a lot, now that we've had a breather, I mean, we've had a week since the launch at ASP, and I was thinking about, and this is not to say we need a policy on this, but all of this focus and the really important lessons Vero has been teaching us about the need for age disaggregation when we talk about children, it's really gotten me thinking when I'm sitting in an evidence review or a discussion where we're talking about persecution even, about the need to disaggregate and talk about all sorts of age ranges, right? The meaning of a crime and the targeting of someone who's of childbearing age versus what might be happening or disparate treatment of folks who are much older. It's important. It's important to think about age when we talk about intersectionality, but also when we talk about persecution itself. Age isn't listed as one of the grounds persecution in the statute, but there is a provision, right, that any other grounds can be considered. So I think the children's policy reminds me that when we look at persecution and also gender-based crimes, it's not only age disaggregation of children that's important, but looking at age ranges of the victims and affected communities at all is important in our analysis. Actually, it'll help us tease out a little bit of the patterning and the motivation behind these crimes. I think maybe a couple other just basic relationships among the policies is we committed to some implementation and monitoring and evaluation. And I think the way we'll do this as a practical matter going forward is finding ways to address implementation of the policies together. So we don't have one implementation strategy for each policy, right? We don't have one set of tools for each strategy, but looking at a much more integrated approach because they are so closely related. Like, how do we develop the tools and the systems to make sure we do these in tandem and holistically? So I think that will be very important. Similarly, when we revise and are finalizing our internal operational guidance, which we unfortunately cannot share with external colleagues, we will be very clear to make sure that analysis references and follows all of the policies. So there'll be a holistic approach to implementation that brings the policies together internally for the OTP. So maybe I'll just stop there, Milena. Thanks.
Sure. I have one last question for Lisa, and then I wanted to turn to some of the questions and comments that we've received from our audience. So the question for Lisa is as follows. The policy on gender persecution was launched about a year ago, and just at this past Assembly of States Parties, I actually had the honor to moderate a side event where you were a speaker as well as Kim on the topic of new principles on gender persecution, prevention, protection, and survivor participation. So I wanted to ask you, Lisa, what is next in terms of the policy on gender persecution? I know you're developing some principles, so tell us a little bit more about what comes next.
Yeah, well, it's next is just what you said. It's the principles on gender persecution. So how is this different from what we've done? Let me answer that. And just to say, it was a great launch to announce the principles last week during the Assembly of State Parties meeting. And everyone should look for the announcement on the website of the Office of the Prosecutor in January. So what are the principles? Well, one question I've received a lot since we've developed the policy on gender persecution is, how does this apply outside of prosecuting this crime in a criminal context? What does it mean for human rights law? Because human rights law also has this incredible dearth on gender persecution. And the technical answer is easy. There are 6 elements under the Rome Statute. The first 3 are the 3 that make up human rights law. But that doesn't really satisfy the question, right? It leaves us hungry for more in terms of, how is it different from gender discrimination? What's the difference between discrimination and persecution? Where's that line? What's that severity that persecution invokes? How can it be implied? How can it be utilized by treaty bodies? And how does it fit into the broader women, peace, and security context? So that's what the principles are really there to be able to draw from. So the idea is to look at the principles in the gender-based crimes policy and the guiding points in the persecution policy and the children's policy, and develop a set of principles that look at prevention, protection, and survivor participation. How do these things work? How do they intersect with human rights? And what are some of the general foundation principles that we need to be thinking about when we're applying this in a broader scope outside of accountability mechanisms? So that's the idea. It's really to respond to the call for more information and how to use gender persecution in other contexts outside of a criminal courtroom. So the process is going to be an announcement in January. There's going to be an open call for civil society comments that will run until through November of 2024. And of course, this is before any drafting takes place, because we know before the pen hits the paper, we need to hear input from civil society, from UN experts, from states on what's important to be included. What should the context of these principles be? Because we know once there's something written, it's really hard to undo what's been done, because you've negotiated over every word, you've come up with a draft. So we're going to do this right. We're going to start by first getting the input and then putting out a draft for a shorter period of comment. And we're going to try and have it really reflect what experts on the ground, those who are really working in the trenches of conflict, what they see, what experts are grappling with, both in the human rights context and in the criminal law context, and hopefully come up with something that, reflects a practical way and a holistic guiding way of how to address gender-based violence wherever they may happen.
Thank you. Now, we have received a few interesting and very different types of questions from our audience members, and also a comment. So let me start with the comment. And this is from Emmanuel Didier, who says, I'm the senior legal counsel of the Yazidi Legal Network. We have been compiling a bibliography and a database on the crimes committed against the Yazidis. It is quite clear that the crimes committed against Yazidi children and women were committed not only because they were Yazidia, but also because of their gender and or age. So, more of a comment rather than a question, but I thought it was important to highlight. We have one fairly straightforward question, which goes as follows. Does the ICC have authority to investigate and prosecute individuals for crimes like gender persecution and sexual violence during our conflict, even in the absence of a Security Council referral? So a fairly technical question, but I think important to clarify. So maybe Lisa or Kim, if you want to take this one on. Maybe I'll start with Lisa. So outside of a Security Council referral, I know the answer, but I think it's important to clarify for our audience members.
Yeah, I was just going to say, Milena, you could answer this too. So could Vero. It's a great question. Yes, of course, because the prosecutor can open his own cases, his own preliminary examinations. They don't have to come through a Security Council referral. There just has to be jurisdiction to be able to do that. And that goes to looking at the identity of the perpetrator or the geographical place where the crimes took place. And just a shout out on the comment about Yazidi victims. I think I couldn't agree more. I've looked at that evidence. Certainly, there are so much evidence and crimes that may amount to gender persecution, crimes against kids, both in many cases. So I'm really glad that point was raised.
And I would just add, in addition to what Lisa gave us, states can also refer cases directly to the ICC. So, in fact, that's what happened in many of our early cases. So, for example, the government of Uganda referred the Lubanga case up. So there are basically three different ways that the case can reach the ICC for consideration through Security Council, as you mentioned, but also the proprio motu power of the prosecutor, him or herself, and then through a state referral. So hopefully that answers that question. I don't know, Milena, if you wanted to add anything. You're
No.
an
I mean,
expert here.
that definitely answers the question. The short answer is yes, definitely. And then Lisa and Kim have just provided a little bit more detail about how a case can end up before the ICC. But I did want to get to another question, and actually there's sort of two questions that I think ask pretty much the same thing. And the question is really about positive complementarity. So one of our attendees says, could you elaborate on ways in which national level investigators and courts can incorporate existing international expertise to prosecute whether it be sexual gender-based crimes or gender persecution. And then the other question, I'll just read both because I think they're sort of asking the same thing. Says one of the panelists mentioned complementarity. Can you tell us a little bit more about how these three policies fit within the court's positive complementarity goals? And actually, we have about 5 minutes left, so I would leave, about a minute and a half to each of you to tackle this very, very complex but very, very important question.
Well, I can just start very, very briefly and say, first, we have a new special advisor on complementarity, whose name is Rene Urena, and he hails from Bogota, Colombia. So it's just another sign of the prosecutor's commitment to this issue, along with the policy that on complementarity as well. That's one of the prosecutor's initiatives. I've been fortunate, and I know Kim has too, to be able to do this work with other jurisdictions that are looking at crimes. I went to Colombia and worked very closely with their judges on the issue of gender persecution, and that really is how these policy papers are so helpful, because we've heard from judges how important it was to have the gender persecution policy paper over this last year, and they're extremely excited now to also have policy papers that have updated the crimes, gender-based crimes and crimes against children to be able to draw from. So they're not just an exercise, they're not policies that just sit on a shelf, they're actually used and marked up. In fact, when I was in meetings with judges in Colombia, one of them showed me the policy, and it just had a bunch of tabs and different multicolor highlighting all over it. And it's just great to see that they're actually being used in the field to understand how to recognize victims and how to bring redress.
Yeah, let me add to that quickly. I think, we have now different cooperation agreements with a couple of different states, which, depending on the text of the agreement, really outline the exchange that can happen, where we can provide, support and some technical assistance there, but also where they can feed into our process and teach us a little bit more about the situation if we are working together in the same context. I think, as Lisa said, these policies in particular, we're hoping to make sure that they're accessible in different languages so they can be rolled out. I was really delighted at ASP, a colleague of mine from a very dear friend who is currently working at the Special Criminal Court in Central African Republic. She asked how many copies of the French version of each policy she could take home and shove in her suitcase, because she really wanted to be able to bring the hard copies to colleagues working at that court, knowing that they would be much more responsive if they could thumb through something, mark it up, as Lisa mentioned. And so in very small ways, we're going to try to make these resources accessible. And I think that it's to the extent possible, our additional guidance, if it's not deeply internal, we'll also try to make some summary or some version of them available. So I think you'll see in the next couple of months, one of my hopes for the Gender and Children's Unit at OTP is that we'll have an internal site where all of our resources are available, but those that are allowed to be public, we'll also find a way to have a central website where we can, people from any jurisdiction can go and gather what we are able to share. So hopefully that will also help.
Thank you. And Veronique, you have the last word.
Thank you very much. I think you've understood that what we're trying to say is this is a big learning process. And on children, there's obviously a need to deepen understanding of gender, social, cultural factor, and developing capacity. For children, it's particularly complex because we all know that children respond differently, whether they're 2, 4, 6, 7, 8, 10, 12-year-old, and so forth. I often speak about under 18 so that this age disaggregation and understanding can be implemented more naturally. And who else can best help assist understand the combination between gender and age is local expert from the context, whether from domestic jurisdiction or all the communities and the expert that actually live and work and have the expertise of what it means to be impacted by a crime at a certain age, of a child of a certain age and of a certain gender. So these include maintaining field presences, developing glossaries with the local terminology that is used when engaging with children of different ages, and again, consulting with national, local experts who have an understanding on gender persecution through the analysis on gender and age disaggregation.
Thank you. Unfortunately, we are out of time for today. Thank you for joining us and submitting all your questions. The webinar recording will be available both on the PILPG website, and it will also be shared with all of our attendees by email. This event was part of the PILPG Thought Leadership Initiative, and it was the 5th in a series of events that we held on the policy on gender persecution. I'm deeply grateful to our panelists for taking the time today to talk about all these 3 policies, as well as to our audience members for their participation. And again, special thanks to Professor Lisa Davis, who has been with us for all the 5 events that we have organized over the course of the summer and fall of 2023. It has been a pleasure discussing all these policies with you and our other experts, and we look forward to continuing discussion in other settings. Thank you so much.